So it's been a minute since I made a video, but here we are. And the reason I'm making this video is we have a small update. And we haven't had an update in forever. And S&P 500 just made new 52-week highs. And so things are looking like they're setting up for something big. And if you remember all the MULN Twitter drama, like with the lawyer that was running this, Mike, is it Mike or Mark Basile? Mark Basile. Like the way the dude has talked and what he has said, like he's definitely winning this suit. And the way that MULN filed the two other lawsuits that all led to garbage, like the first one was legit and they fucking swept it under the rug, and then the second one was garbage and just a copy of other people's lawsuits. And then this one is the one that came with Mark Basile, like tooting his horn or whatever. And so this is the complaint that was filed on December 28th. It wasn't available to the public, at least until the last week or two. I haven't checked it in maybe a week, and it wasn't available last time I checked it. So we're going to read through the complaint real quick. And what to know is that basically, I don't know exactly what a stay is, but I assume that means prolong, like some type of delay. But the defendants asked for a stay, and the courts granted a temporary stay until March 21st, which is tomorrow. And we are, like MULN's, required to go and plead their case on the 21st, why the defendant's motion should be denied, and hopefully lead to a quick settlement or something. But let's look at this. It says Plaintiff MULN Technologies. Okay, we'll start an introduction. The GEM defendants are unregistered security dealers that purchase security directly from issuers and promptly, if not immediately, sell those securities, or securities acquired through exercises of convertible securities like warrants, despite failing to comply with the Securities Exchange Act, which avoids such transactions. Unregistered security dealers, such as GEM defendants, hold themselves out to be legally authorized to enter into security transactions, such as warrant. That is subject to litigation. Despite failing to register as a dealer with the U.S. Securities and Exchange Commission, and despite the fact that the Act strictly prohibits unregistered securities dealers from effecting transactions in securities. Stated simply, GEM defendants' business model is illegal.
Bro, get the fuck out of here.
Alright, where was I? Something is illegal. Okay, so number 3, stated simply, GEM defendants' business model is illegal as reflected in recent SEC prosecutions. Unregistered security dealers, like the GEM defendants, avoid registering so they can evade regulatory oversight and enter into securities contracts such as share purchase agreements and warrants that generate outrageous and unlawful profits. Indeed, in recent civil actions, the SEC has sued various unregistered security dealers that use the GEM defendants' business model for unlawfully operating as unregistered security dealers in violation of Section 15. Every court to address this issue has agreed with the SEC finding that buying and selling securities as a business for one's own account constitutes securities dealer behavior as a matter of law. Sounds like they're nailed to the wall. The warrant in this case is unlawful because it was made in violation of Section 15 of the Act. Additionally, Defendant Brown is in violation of Section 20A of the Act as the control person. For the GEM defendants, he authorizes, controls, and directs the GEM defendants to engage and transact in securities without effective registration as dealers. Therefore, plaintiffs seek rescission of the warrant attorney fees and any and all relief that the court deemed just, proper, and interest of justice. Jurisdiction venue. Okay. The parties. Plaintiff MTI is California Corporation. Plaintiff MAI is Delaware Corporation with its principal executive located at 14. Defendant applicable federal statutes. The SEC requires dealers to register and promulgates as follows. So just it's the actual code that they're in violation of. Factual allegations. The GEM defendants' general business model violating federal securities law by operating as unregistered dealers. The GEM defendants have engaged in a multitude of security transactions over the past 5 years. Predominantly, the GEM defendants enter into purchase agreements, securities with various issuers to purchase the issuer's common stock securities for an aggregate amount of cash. Under these share purchase agreement, warrant securities are generally issued where the GEM defendants are permitted to purchase a specific amount of issuer's common stock. As of 2019, GEM Global has effected at least 26 security transactions with at least 18 different issuers and has purchased common stock and exercised warrants with no fewer than 117 million shares of newly issued common stock that GEM globally subsequently sold on the public markets for substantial profits. As of 2019, GEM Bahamas has effected at least 41 security transactions with at least 31 different issuers and has purchased common stock and exercised warrants with no fewer than 65 million shares of newly issued common stock that GEM Bahamas subsequently sold on the secondary market for a substantial profit. Upon information and belief, the GEM defendants as business continue to unlawfully purchase securities under the share purchase agreements with public company issuers and acquire warrants and shares of common stock through, for example, exercise of warrants, and then sell those shares into the public markets to reap profits from their own account. In the last 6 months alone, GEM defendants effected at least 4 separate security transactions with at least 4 public company issuers: Surf Air Mobility, 4 million shares, Re-Alpha Tech Corp, 1.7 million, NRX Pharmaceuticals, and Jet AI. The GEM defendants' purchase of common stock and warrant security transactions, exercise of warrant security transactions, and subsequent stock sales security transactions are part of ongoing business. The GEM defendants acquire large volumes of shares directly from issuers and at a discount to prevailing market prices, and then rapidly sell the newly acquired shares back into the open market in order to lock in profits generated from the spread between their discounted acquisition price and the prevailing market price, rather than realizing profits from an appreciation in the securities market price. Stated differently, the GEM defendants sell the newly acquired securities absent investment intent. The GEM defendants do all of this by exercise and sell securities as part of their regular business for their own account. Upon information and belief, the GEM defendants made use of the mails, email, and other instrumentalities of interstate commerce to effect the security transactions, such as using the internet to solicit issuers, transferring cash through wire transfers, and using email and telephone communications to negotiate and effectuate sales transactions through their brokers. Upon information and belief, the GEM defendants paid several independent contractors to assist them in locating, negotiating, and managing the GEM defendants' transactions. By failing to comply with the dealer registration requirement, the federal securities law, the GEM defendants purposefully operated under the radar to avoid important regulatory obligations that govern dealer conduct in the marketplace, including submitting to regulatory inspections and oversight, following financial responsibility rules, and maintaining books and records. Any person engaged in the business of buying and selling securities for such person's own account, through a broker or otherwise, as part of a regular business, must register as a dealer with the SEC, or in the case of a natural person, associate with a registered dealer. While the GEM defendants engaged in the conduct, they were not registered with the SEC as dealers or associated with dealers registered with the SEC. A person who engages in dealer activity must file an application on a form called Form BD, which asks questions about the applicant and its principals. Controlling persons and employees. An applicant must file the Form BD with the Central Registration Depository, which is operated by FINRA. The dealer registration requirement provide important safeguards for the investing public. For example, registration with the SEC requires the dealer to disclose important information about its business, including but not limited to the names of the direct and indirect owners, the executive officers of the business, certain arrangements with other persons and entities, the identities of those who control the business, the states in which the dealer does business, past criminal and regulatory actions against the dealer or any affiliated person that controls the business, and financial information including bankruptcy history. Further registration requirements mandates the dealer to join a self-regulatory organization such as FINRA or a national security exchange which assists the SEC in regulating the activities of registered dealers. Finally, registered dealers are subject to inspection by the SEC and FINRA to ensure they comply with the securities law. The GEM defendant's business model applied to plaintiffs. The GEM defendant's purchase made the warrant security from MTI. The GEM defendant's business model, as reflected in the conduct alleged above, manifests numerous and substantial characteristics of dealer activity consistent with ongoing SEC civil prosecutions and federal court decisions. Chief among these characteristics is the ability to purchase common stock and warrants through share purchase agreements, pursuant to which the GEM defendants acquire securities directly from an issuer through warrant exercises from their own account. As defined in the Act, the warrant in this case is a security, and therefore the GEM defendant's acquisition of the warrant is a transaction in securities. The GEM defendants made use of mails, emails, and instrumentalities of interstate commerce to effect the warrant and agreements. The agreements provided MTI with financing facility of an initial $350 million with the potential to increase the available funds to $500 million on the terms and conditions provided in the agreements. The financing facility was implemented by the SPA, which required the GEM defendants to purchase MTI's common shares from time to time upon MTI's delivery of drawdown notices as defined in the SPA, up the number of shares valued at an agreed aggregate limit as defined in the SPA. The aggregate limit was set initially at $350 million, with the provision of MTI to increase the aggregate limit to $500 million. As consideration for providing the financing facility, the GEM defendants were to receive a commitment fee of 2% of the agreement limit payable on the anniversary of the first trading day, as defined in the SPA, and after MTI became publicly traded company, either through an initial public offering or reverse merger transaction. And the warrant, which entitled GEM defendants to purchase shares valued at 6.6% of MTI's public shares on a fully diluted basis at an exercise price equal to or lesser of the closing bid price of MTI's common stock on the open market of the date of exercise, quotient resulting from $7.4 billion divided by the total number of common shares outstanding of the date of exercise. Because GEM defendants effected the warrant as an unregistered dealer and utilized means of interstate commerce in connection therewith, the warrant was unlawful when made. Brown controls the GEM defendants' business operations. At all relevant times, Brown served as manager of GEM and directly possessed and exercised control of GEM defendants, including the power to decide whether to enter into agreements, including the warrant in this case, to negotiate and approve the final deals and terms, and direct its sales of stock. Upon information and belief, Brown negotiated the terms of the purchase agreement with the GEM defendants, purchased from companies including MTI, as well as amendments in the original terms. Ultimately, Brown is and still the GEM defendants' manager and sole person holding the power to direct, authorize, and compel the GEM defendants to enter into security contracts, including the warrant. Defendant Brown was and currently is the controlling person within the meaning of Section 20A of the Act, with the power of the GEM defendants to engage in unlawful conduct described herein. Count 1. Rescission pursuant to Section 29B of the Act of violating Section 15A of the Act affecting making the agreement as unregistered dealers against GEM defendants. Plaintiffs repeat, reiterate, and reallege each and every allegation of paragraphs 1 through 48 as though set forth herein. Section 29B of the Exchange Act provides in relevant part that every contract made in violation of any provision of this chapter of any rule or regulation thereunder shall be void. As regards the rights of any person who in violation of any such provision, rule, or regulation shall have made or engaged in the performance of any such contract, The warrant was made in violation of Section 15A of the Act, which prohibits unregistered dealers from using any means of interstate commerce of effect transactions in securities. The GEM defendants are security dealers with the meaning of the Act. The GEM defendants are not registered as dealers with the SEC or any regulatory body as required in Section 15A. The GEM defendants effected a transaction in securities when they executed the warrant. The GEM defendants used means of interstate commerce to effect the securities transaction under the warrant, such as use of internet website or use of email, telephone. As a party of the warrant, MTI is contractually privity with the GEM. Is in contractual privity with the GEM defendants. The registration requirement is designed to protect stock issuers and others from unscrupulous and unqualified agents engaged in dealer activities. According to MTI, as an issuer is within the class of persons and the act was designed to protect. Because the GEM defendants effected the securities transaction under the warrant as an unregistered dealer that utilized means of the interstate commerce in connection therewith, the warrant was unlawful when made. During the relevant period, Brown was manager of GEM defendants who had control and authority to direct GEM defendants in its business practice of engaging issuers at all relevant times. Brown did not act in good faith, which supported the fact that Brown previously registered as a broker for the last 7 security firms from February 1986 through 2001. Therefore, was aware of registration requirements under the Act from prior industry experience, but chose to disregard them. At the time of the execution of the warrant, Brown knew that GEM defendants were not registered as dealers with the SEC, which is supported by the fact that Brown was previously registered as a broker for at least 7 securities firms from February 1986 through 2001, and therefore knew the registration requirements under the Act, but chose to disregard them. Brown was listed as the individual manager to receive all relevant notices on behalf of GEM Global and GEM Bahamas under the warrant. Brown directly and indirectly induced the acts and conduct that constitutes the violations in this action. Therefore, Brown acted as a controlled person of GEM defendants within the meaning of the SEC Act. Wherefore, plaintiffs seek a verdict judgment against defendants herein as follows. Rescinding the warrants pursuant to Section 29B of the Act, 15 U.S.C., awarding rescissionary damages, and such other relief as the court deems just and equitable to effectuate the voiding and rescission of the warrant, awarding plaintiffs their attorney fees and costs associated with the litigation, and awarding such further additional legal and equitable relief that the court deems just and proper and in the interest of justice. Plaintiffs demand a trial by jury on all issues properly so tried. So, it sounds like they're guilty. It sounds like the meeting is happening tomorrow. And again, stock market at all times high. Like, if these warrants have a rescission, like, try to understand what that means. So, if the market's gone down because of these one people that, like, made a deal with MULN, like, you think MULN would, like, validate to make sure they're registered dealers before going into a contract with them? That's a little weird. But the idea is that because they weren't registered dealers and because they made a deal, they were able to utilize the warrants in an illegal manner, which crushed the stock price worse than any stock's ever been crushed, especially compared to how much was getting bought. And because they're unregistered, the SEC was incapable. Like, the systems are so archaic and their job is so structured and defined, they're not allowed to look at MULN and say, let's look into this and see if anyone's breaking the law. They have to wait until it gets brought up in court. But again, the idea would be that if these warrants were all illegal, then they would get pulled off the table in some manner, but which would sound like a short squeeze, but not coming from the short, but coming from the court ruling of saying that these shares were illegal to begin with. I don't know. Like, if you go listen to Mark Basile back in the day, I know he was saying that. Like, he was saying I wasn't just... He was saying we weren't going to just sue these people for the money they made, but we were going to have these shares taken off the market. So, I don't know. It sounds like a possible catalyst. They wouldn't let me read this stupid complaint for 3 fucking months. And now that you can read it, maybe it's because it's about to be some mainstream news. That's what I'm thinking. Other than that, I got some big things in the works. If MULN takes another 3 months to squeeze, like, I'll be $10 million deep probably. So I'm excited. But I'll talk more about that in like a month, maybe 2 months, when I got some cash in the bank.